you, Mr. Chairman and honorable members. The 4 issues framed by my learned friend here are well canvassed by my colleagues here. You permit me, Mr. Chairman, to add on to those 3 issues. But before I do so, Mr. Chairman, just 1 to 3 minutes to reinforce the 2 issues, the first 2 issues Council Kalibara raised with authorities on this. The arguments have been adequately canvassed, and we are convinced this honorable court is frustrated by those submissions. Now, with authorities on vagueness of Section 128, that is issue number 1. The vagueness, the uncertainty of that particular provision. The Constitutional Court has had occasion to pronounce itself on that particular matter in the case of Andrew Karamachi. I'll furnish you the copy with you. Rather, I'll furnish you the copy. Andrew Karamachi, Robert Shaka versus the other. Constitutional petition number 5 of 2016. But the point emphasized here, Mr. Chairman, the doctrine of vagueness in the legislation. This is what they said on page 10. This is the Constitutional Court. The doctrine of vagueness is founded on rule of law. The doctrine of vagueness is founded on the rule of law, particularly on the principles of fair notice to citizens and the limitation of enforcement discretion. Fair notice to the citizen comprises a formal aspect, an acquaintance with actual text of a statute, and a substantive aspect, an understanding that certain conduct is subject to legal restrictions. The crux of the concern for limitation of enforcement is that the law must not be so devoid of precision in its content that a conviction will automatically flow from the decision to prosecute. The threshold for finding a law vague is relatively high, and this is what they set as a standard. The factors to be considered in determining whether the law is vague or not: A, the need for flexibility and the interpretative role of the courts, that is number 1. 2, the impossibility of achieving absolute certainty. A standard of intelligibility being more appropriate. That standard of intelligibility is critical and crucial. 3, the possibility that many varying judicial interpretations of a given disposition may exist and perhaps coexist. They cited the case of Nova Scotia Pharmaceutical. It is a 1992 decision which you find here. So the doctrine of vagueness can be summed up in one proposition. This is how they summed it up, the Constitutional Court. A law will be found unconstitutionally vague if it lacks in precision as not to give sufficient guidance for legal debate. That is, for reaching a conclusion as to its meaning by reasoned analysis applying legal criteria. The term legal debate is not used. The term legal debate is not used to express a new standard or one departing from that previously outlined by this court. It is rather intended to reflect and encompass the same standard and criteria of fair notice and limitation of enforcement discretion viewed in fuller context of analysis and quality and limits of human knowledge and understanding in the operation of the law. The criterion of absence of legal debate, and so it continues and continues. And finally, Mr. Chairman, this is the decision they arrived at after analyzing all that. The statute is also void for vagueness if a legislature's delegation of authority to judges or administrators, like this General Court Martial, is so extensive that it would lead to arbitrary prosecutions. I need to emphasize this. A statute is also void for vagueness if a legislature's delegation of authority to judges or administrators is so extensive that it would lead to arbitrary prosecutions. Vague laws involve three basic dangers, and this is what we want to caution against. This is what they stated. Vague laws involve three basic dangers. One, they may harm the innocent by failing to warn of the offense. Ignorance of law is not defense, yet the law itself is vague. Two, they encourage arbitrary and discriminatory enforcement because vague laws delegate enforcement and statutory interpretation to individual government officials. Laws are usually found void for vagueness if after setting some requirement or punishment, the law does not specify what is required or what conduct is punishable. Also, an enactment is void for vagueness if its prohibitions are not clearly defined. Finally, Article 28(12) is very clear. It requires that an offense must be defined. That definition, in my view, must be clear enough to enable citizens to distinguish between the prohibited conduct and the permissible. Any vague interpretation will lead to satisfy the requirement of Article 28. In fact, the case of Charles Onyango versus the Attorney General. So this authority by the Constitutional Court, which has got that primary obligation of interpreting the Constitution, is binding on this and it's very instructive in that when you look at Section 128, it opens floodgates. It cuts the net wide offenses relating to security and punishment, death. This is how serious it is. So a vague law to subject somebody to a death penalty is something that cannot be sanctioned by the existing constitutional order. And the reason we are asking, we need interpretation of the constitutional court about that particular provision. So that is the authority in regard to the vagueness of Section 128 relating to offences compromising security. The other issue, the second